Hi, everyone. Thank you for joining us today for the 2021 bid protest decisions with far-reaching impacts for government contractors. I am Katie Burrows. I'm a partner in the government contracts group of PilieroMazza and lead the bid protest practice for Piliero. As you can see from my bio, my practice focuses on bid protests, REAs, investigations, key TAM suits, false claim act matters, contract claims before the various boards of appeals, and so on and so forth. So my practice does focus on the litigation side of government contracts. I have with me here my associate in crime, Eric Valle, and I'll let him introduce himself.
Thanks, Katie, and good afternoon, everyone. My name is Eric Valle. I'm an associate in PilieroMazza's government contracts group, and as you can see from my bio as well, I focus on all aspects of litigating against the federal government, including bid protests. Prior to joining PilieroMazza, I clerked at the Court of Federal Claims for the Honorable Matthew Solemson, where I gained a great deal of experience in handling bid protests in front of the Court of Federal Claims.
And just to give everyone a little brief background about PilieroMazza, we are a full-service law firm and regularly handle litigation claims, general commercial litigation, government contracts. We also have a labor and employment group, and a corporate transactional group also who does M&A work, intellectual property, things of that nature. So this slide just kind of gives you an overview of the areas that our firm, highlights of the areas that our firm practices in. So the reason we're here today to talk, we'll give you a little bit of an overview, a brief overview on bid protests, and we'll talk about the recent bid protest statistics, regarding GAO and the Court of Federal Claims, and then we'll get into the meat of the webinar, which is to discuss some of the important decisions we've seen over the last year. And those decisions fall under these categories of solicitation challenges, timing, post-award challenges, and record issues for today's purposes. And then we'll give you a few protest tips at the end. Okay, so just a little brief background on what a bid protest is for those who haven't been involved in one before. But, in its simplest form, bid protest is a challenge to an agency's procurement decisions and actions. And in this context, we're talking about federal procurements. It is important to note that bid protests are different from size or status protests. Those types of protests deal with size and socioeconomic status of the awardee, and they're handled by the Small Business Administration, the SBA, as opposed to bid protests. And we'll talk about the various forums that they're involved in. There are two types of bid protests: pre-award and post-award protests. And then, unlike size or status protests that's before it's handled by the SBA, bid protests can be before whatever agencies handling the procurement, or the U.S. Government Accountability Office, GAO, which is, the most frequent place that we see protests being filed. The Court of Federal Claims, and in my practice, I think, my experience, I've seen there be an increase in protests at the court in my own practice. And then for FAA procurements, ODRA, which is FAA's Office of Dispute Resolution Acquisitions, that's the specific forum for FAA procurements.
So now we're
Eric,
going to talk about, yeah.
Go ahead.
So now we're going to get into the recent bid protest statistic. And Frederick, you can click to the next slide. So each year GAO puts out a report. It issues a report to Congress, and it reports on its bid protest statistics. In the most recent fiscal year, GAO's protest, the number of cases filed with GAO was down by around 12% from the previous fiscal year. That continued a trend, a year-over-year trend for the previous 3 years of declining protests, and protests have been in decline at GAO, in fact, 4 of the 5 previous fiscal years. While GAO doesn't, put out reports investigating why there's this downward trend, we typically in the past few years have chalked this up to increased information during the debriefing process, particularly the DoD's enhanced debriefing process. And in the most recent few years, I think we could attribute some of that decline to perhaps the pandemic situation and some of the issues there. But we're not quite sure exactly why there is the decline in cases at the GAO. In addition to the decline, we always think about 2 paths to victory when we're, filing a GAO protest or when you're defending against the GAO protest. And there's really 2 chances for success. The first is at the corrective action stage. And at that stage, GAO has a 48% effectiveness rate. And GAO's effectiveness rate is just relief for the protester in the form of corrective action or a sustained protest. So in about 1 out of every 2 GAO protests filed, the protester is going to get some relief in the form of corrective action or a sustained protest. So, trying to convince the agency in your initial protest that you have solid grounds and that there was a mistake made is an effective strategy, as agencies will often take corrective action to correct that. And from the intervener's perspective, trying to engage with the agency early on in the protest process and to convince the agency that there is no reason to take corrective action and that the award to, your company was correct is also a really important stage. When you get beyond the corrective action stage, when you go to a merits decision at GAO, the sustain rate or the effectiveness rate essentially at that stage dramatically decreases. A protester has about a 15% chance of success, shown through GAO's 15% sustain rate in the last year. And that sustain rate is fairly consistent over the past 5 years. It generally hovers right around that 15% number. So once you reach the merits as a protester, you have less likelihood of success at GAO. In the intervener's perspective, you have just a greater chance that GAO will deny the protest. Again, however, not all protests are created equal, so it's not like you can take these statistics and use them as a probability going in. It is all highly dependent on the facts and circumstances of your case. And Frederick, can we go to the next slide? GAO also releases its most numerous sustained arguments, and those arguments, those grounds that typically get sustained include an unreasonable technical evaluation, flawed discussions, an unreasonable cost or price evaluation, and unequal treatment between the offerers. There's not a whole lot that you can glean from these broad categories of protest grounds that get sustained. For example, the number of different types of protest arguments that get categorized as unreasonable technical evaluation arguments, there are many of those different types of arguments to make. So all of these are to say that the particular facts of your protest are going to govern how you make the arguments and what arguments you make. But these are some issues that from the firm side, from the company side, as you start to get debriefing documents and as you start to gather information about what happened during the course of this procurement, you can be on the lookout for these issues and start to spot whether you have potentially a reasonable chance of success based on some of these sustained arguments that GAO frequently sustains. Frederick, next slide. When it comes to the Court of Federal Claims, the court does not release a detailed report like GAO does each year, so the statistics are a little bit harder to come by. You'd have to actually do an analysis of each of the cases and keep the statistics for yourself. The court does, however, release the number of protests that were filed with the court, and in the most recent year of stats, fiscal year 20, there were 120 protests filed with the court. That number is significantly less than the number at GAO, where there were 1,800 cases filed with GAO last year. But as Katie mentioned earlier, that number anecdotally in our practice has increased. In addition to the increase in protests at the court, we've also seen over the most recent few years just an influx of new judges. At the court, there were a number of vacancies about 5 years ago, and now through the Trump presidency, President Trump appointed 10 new appointees to the court. So 10 of the 12 active judges on the bench are brand new, less than 4 years on the court, and 2 of the 12 active judges on the bench have more than 4 years of experience on the court. That, however, does not mean that the new judges to the court are inexperienced or not steeped in government contract and bid protest case law. I think there is an exciting body of case law coming out of the court, and the court is really digging into the issues and giving a lot of consideration to each protest argument that the court has before it. And those are reflected in the court's decisions that we're going to talk about during the course of this presentation. And so with that, Frederick, go to the next slide. I'm going to turn it back over to Katie.
Thanks, Eric. So the first case we're going to talk about deals with a pre-award protest of a solicitation requirement, and that is InfoPoint. And this was before GAO. This was an interesting protest, and probably one that there are numerous contractors out there that are interested in. In this case, this pre-award protest challenged the solicitation requirement. It was an Air Force solicitation that a joint venture that was competing for the award, as opposed to individual members of the joint venture, had to hold a top secret facility clearance. So that was protested. And it came up in response to a question from an offeror in the question and answer period, that the Air Force, clarifying that the JV itself must hold the facility clearance as opposed to the individual partners. And the Air Force did confirm that was the requirement based on DoD guidance and the Air Force manual. The Air Force also answered a question regarding SBA regulation at 13 CFR 121.103H4. And that question addressed the evaluation of facility clearances for small business joint ventures. And the Air Force advised that the small business regulation, notwithstanding that the requirement was consistent with the DoD manual and Air Force manual. And so the Air Force wasn't going to amend the solicitation to comply with that SBA regulation. SBA was asked to provide comments in this protest, given that it involved a significant small business regulation. And SBA agreed with InfoPoint, the protester, and argued that the regulation, that the SBA regulation was consistent with the 2020 NDAA, which prohibited the government procurement requirements that the JV itself hold the facility clearance as opposed to the individual members. Ultimately, GAO found that there were 2 relevant statutory provisions as well as the implementing regulations that were at issue. First was Section 644 of the Small Business Act, which specifically states that when evaluating an offer of a joint venture of small business concerns, if the joint venture does not demonstrate sufficient capabilities or past performance to be considered for award of a contract opportunity, the head of the agency shall consider the capabilities and past performance of each member of the joint venture as the capabilities and past performance of the joint venture. So, and then the other statutory provision that GAO said was at issue was the 2020 NDAA, which was enacted at the end of 2019. And the 2020 NDAA contains a provision that directly addresses the requirement that a joint venture have a facility clearance. It specifically said, and this is section 1629 of the 2020 NDAA, which specifically said termination of requirement for Department of Defense facility access clearances for joint ventures composed of previously cleared entities. And it said a clearance for access to a DoD installation or facility may not be required for a joint venture if that joint venture is composed entirely of entities that are currently cleared for access to such installation or facility. In addition to that, SBA had issued a final rule in October of 2020 that implemented its interpretation of the Small Business Act and the 2020 NDAA. And that regulation provided that a joint venture may be awarded a contract requiring a facility security clearance where either the joint venture itself or the individual partners to the joint venture will perform the necessary security work and have facility security clearance. So ultimately, the GAO was persuaded by the SBA and the protester there and disagreed with the Air Force. So it is a really important decision because even since this decision, in my practice, I've seen solicitations, DoD solicitations in particular, that have included a similar requirement as an info point. And in response, instead of filing a pre-award protest, we've sent letters to the agency explaining why that requirement, didn't comply with the various regulations. And this info point case has been very helpful in that regard. So let's see, moving on to the next case. Eric, you want to talk about the timing of Nika Technologies case?
Yeah, so as just a little background, as Katie described up front, there are essentially two protest forums that we typically go to at the outset: GAO or the Court of Federal Claims. If you protest at GAO, you typically don't have an appeal right. Although in certain circumstances, you can bring that same protest at the Court of Federal Claims at a later date after GAO sustains or denies your decision. At the Court of Federal Claims, if you lose or if the government loses its protest, there is an appeal right to the Federal Circuit. And when the Federal Circuit issues a decision, that decision is always going to be impactful for the bid protest community because it is binding on the lower court judges of the Court of Federal Claims. With that in mind, the Federal Circuit issued a ruling, Nika Technologies, this year that clarified some timeliness rules. And as a government contractor, timeliness of your protest is always going to be, or always should be, front of mind. If you do not bring your protest in a timely fashion, you can lose your right to protest at the GAO, and you can also have some negative consequences of, delay at the Court of Federal Claims. So by statute, protesters are entitled to an automatic stay of an award or performance of the award if they file a protest at GAO within 10 days of contract award or within 5 days after the debriefing date offered for any debriefing that is requested and required, the later of those 2 dates. That automatic stay is one of the most important reasons that certain protesters decide to go to the GAO rather than the Court of Federal Claims, as an incumbent contractor, that automatic stay goes into place, and you get to keep performing your contract until GAO resolves the protest and the agency makes another award or affirms its award at that time. There are other reasons that you want the automatic stay in certain circumstances, and the Court of Federal Claims does not provide that. So if you file within those statutory deadlines, you get the automatic stay at GAO. In certain DoD procurements, another statute provides that the debriefing shall include an opportunity for a disappointed offer to submit questions within 2 business days after receiving their post-award debriefing. And it was the interplay of those 2 statutes that created some confusion over the past year going on. So in particular, there was some confusion whether your 5-day protest period at GAO to enact or trigger the automatic stay started running when the protester received their debriefing, or whether it started running after the 2-day period that they had to answer or ask questions within elapsed. In NECA, the Federal Circuit resolved this issue. So NECA was an unsuccessful offer. On March 4th of the previous year, the agency sent NECA their written debriefing and alerted NECA that they had the right to submit additional questions within 2 days because this was a DoD procurement. NECA did not submit any additional questions at that time, and they ended up filing their protest at GAO on March 10th. That was 6 days after they had received their debriefing, but 4 days after the 2-day period had elapsed. And NECA said that they were entitled to the automatic stay. GAO, however, denied the stay and said that they had received their debriefing, they were 6 days past, and therefore they were not entitled to the stay. NECA then took their protest over and filed an action at the Court of Federal Claims challenging that ruling to not stay the contract was arbitrary. And the Court of Federal Claims actually agreed with the NECA, holding essentially that their debriefing period did not conclude until the end of that second day, that they had to submit questions, therefore their protest was timely and they were entitled to the stay. The government appealed this and the case went to the Federal Circuit. And the Federal Circuit disagreed with the Court of Federal Claims holding and agreed with the prior GAO holding. The circuit held that the plain meaning of the statute is that the deadline is 5 days after receipt of the debriefing. In other words, the debriefing is not automatically held open for that additional 2-day period that the DoD statute provided. As support for that, the Federal Circuit also looked at another portion of the DoD statute, which says that when there are additional questions, when you submit additional questions within those 2 days, the agency shall not consider the debriefing to be concluded until the agency provides its written responses to those questions. So by implication, when a protester does not submit additional questions within that 2-day period, the debriefing is not held open and it concludes on the day that you receive the debriefing. So to really sum up that rule, if you receive a debriefing and you have an enhanced debriefing situation due to a DoD procurement, you have 2 days to submit additional questions. If you don't submit additional questions within those 2 days, your 5-day period to protest and get the automatic stay at GAO started 2 days ago when you received your initial debriefing. If you submit the additional questions within that 2-day period, your 5-day period to protest at GAO does not start until you receive the agency's answers to your additional questions back in writing. And then you have 5 days from that period going forward. And that rule is just important to keep in mind as a contractor, because if you decide that you want to protest and you think that the automatic stay is important to your company from a litigation perspective or from a business perspective, and you've miscalculated that timing, the rule is just firm and GAO will not, grant the stay or enforce the stay, and neither will the Court of Federal Claims at this point because the Federal Circuit has definitively ruled against that. So that's an important timeliness rule just to keep in mind. Frederick, we can go to the next slide.
Eric, are you going to talk about Harmonia Holdings? Frederick, do you know if can you tell if Eric is on mute or if we're having some technical glitches here?
Hello, can you hear me?
Yeah, I can now.
Hi, Katie. I'm sorry for that, everyone. I'm not sure how I got disconnected. Katie, I don't know if you jumped into Harmonia or if you want me to
No,
take it
go
up from
ahead.
here.
I was not sure what was going on there, but yeah, no, go ahead.
Yeah, I apologize for that. I got disconnected somehow. So another important decision from the Federal Circuit this year that affects bid protests and specifically the timeliness of a bid protest came out in Harmonia Holdings. And in prior cases, in a rather infamous case called Blue and Gold, the Federal Circuit held that any party that has the opportunity to object to the terms of the solicitation that contains a patent error, which is an obvious error, but fails to do so, fails to object prior to the close of bidding, waives its ability to raise those same objections in a bid protest at the Court of Federal Claims. And the purpose of the Blue and Gold waiver rule was to prevent bidders who are aware of solicitation defects from waiting to bring their challenge until after award in an attempt to restart the bidding process. The Federal Circuit basically held that, when something is obvious on the face of the solicitation, that's an error. We don't want to encourage offers to wait until after they see if they've won or lost the award to then protest and restart the procurement at stage one. In subsequent cases, the Federal Circuit and the Court of Federal Claims have kind of expanded the Blue and Gold holding, finding that several different types of challenges were waived pursuant to Blue and Gold. It went a little bit beyond this original rule of a patent error in the solicitation. In Harmonia, the Federal Circuit held that a timely filed pre-award agency level protest preserves an offeror's ability to later file that same protest post-award at the Court of Federal Claims. And the facts of this case are where this ruling gets slightly significant. So on July 12th, the agency in this protest issued a solicitation. In October of that year, October 26th, they issued Amendment 9 to the solicitation, and on November 1st, the agency issued Amendment 10 to the same solicitation. The offeror's proposal revisions in response to Amendment 9 and 10 were due on November 13th, 2018. And so one day before the proposal submission due date for Amendment 9 and 10, Harmonia submitted a pre-award agency-level protest to the agency, claiming that there were errors in the solicitation that were obvious and needed to be resolved. The next day, on November 13th, and this is particularly important, Harmonia submitted a proposal to the agency with revisions for Amendments 9 and 10 based on Amendments 9 and 10. About a month later, the agency denied Harmonia's agency-level protest. And then about 5 months passed, and in April, the end of April 2019, the agency informed Harmonia that its proposal was unsuccessful and that another offer had won the contract, was the best value to the government. About 2 weeks later, after that, Harmonia filed a bid protest with the Court of Federal Claims, raising the same challenges that it had raised some 5.5 months earlier in its agency-level protest that had been denied. So 5 months after CBP, the agency denied Harmonia's protest. 2 weeks after award, Harmonia raises these same pre-award challenges in a Court of Federal Claims protest. The Court of Federal Claims denied Harmonia's protest, and said that Harmonia had waived its pre-award agency level protest challenges because it had waited too long to file that same challenge in the Court of Federal Claims. And Harmonia appealed that decision to the Federal Circuit. Harmonia argued that the Court of Federal Claims improperly extended this blue and gold rule by finding waiver, even though Harmonia had timely filed its challenge pre-award with the agency. The government argued in response that the blue and gold waiver rule should apply, even though Harmonia timely submitted that challenge, because Harmonia had delayed 5.5 months until after award of the contract to re-raise those challenges in a Court of Federal Claims protest. And essentially, the government argued that this went against the spirit of the blue and gold waiver rule. The Federal Circuit agreed with Harmonia, however. They held that Harmonia's undisputedly timely formal challenge of the solicitation before the agency removes the case from blue and gold and its progeny. So what that tells potential offerers and government contractors is that you can file your protest with the agency prior to the solicitation due date or prior to the due date for submission of proposals. And then you could even wait until after award to file your protest at the Court of Federal Claims if the agency denies your agency level protest. However, the significant portion of the Federal Circuit's decision, I'm going to read to everyone. It says, our opinion should not be read as condoning delay in filing actions in the Court of Federal Claims. Under certain circumstances, delaying bidders may face adverse consequences, but we are not persuaded in this case that the imposition of the blue and gold waiver rule should be one of those consequences. The Court of Federal Claims has relatively broad authority to fashion a remedy. The court may award any relief that the court considers proper. On remand, the Court of Federal Claims might decide under the circumstances of this case whether that injunctive relief is appropriate. So what the Federal Circuit guided the Court of Federal Claims on remand was to consider whether the delay would have some impact on the protester in obtaining injunctive relief. And in a Court of Federal Claims protest, injunctive relief is substantive, meaningful relief. Injunctive relief means that the court will enjoin the award of the contract or enjoin the solicitation and make the agency go back and make another decision or craft a better solicitation provision. So I think that the teaching of Harmonia here is that, well, you can wait until after award to file your protest at the Court of Federal Claims if you had timely filed a pre-award challenge and then also submitted your solicitation. You may face adverse consequences going forward and may not actually be entitled to meaningful relief if you delay too long in bringing that challenge. We're going to keep watching the decision on remand, and we'll very likely issue a blog post regarding the decision on remand to see whether the Court of Federal Claims imposes some of this guidance on the protester going forward and denies injunctive relief on the basis of the protester's delay. With that, I'm going to turn it back over to Katie.
Thanks, Eric. So turning to post-award challenges, a recent decision out of the Court of Federal Claims, actually in a case where we represented the intervener in this case, is a case called Golden IT. And it's a pretty interesting, I mean, there were a multitude of issues in this case, but the one that, I think is the most important thing that came out of this case, or interesting anyway, is the claim, the court's opinion involving the claim that the awardee had failed to notify the agency of the alleged unavailability of one of its proposed key personnel. As I'm sure, many contractors are aware, GAO has long held that an offer is obligated to advise an agency of material changes in its proposed staffing, even after the submission of proposals. And the court noted that long-standing GAO rule. in Golden IT, the court acknowledged the quote unquote likely obligation that an offeror has to ascertain the continuing availability of key personnel, at the time of submission of final proposal revisions. But the court noted that it's unable to locate the basis for the GAO's rule that, offerors are obligated to advise agencies of material changes in proposed staffing even after submission of proposals. And further stated that GAO's rule that offerors are obligated to notify agencies of changes in the status of their proposed key personnel, the court said, strikes the court candidly as without legal basis and unfair. Now, the court went on to say that, where contemplated in a solicitation, the government typically has discretion to engage in discussions to verify proposal details, to get more information from offerors, and whether or not to seek final proposal revisions for the purpose of, among other things, confirming key personnel. But the court said it would not conjure up a rule, and particularly not one untethered from a statute, regulation, or federal that requires offerors or quoters to routinely update the government when facts and circumstances change post-proposal or quote submission during the course of the government's evaluation period. Now, obviously, that's in stark contrast to the GAO rule. And the court did specifically say that it declines to follow that line of GAO decisions, and noted an earlier case from 2005 where Judge Wolski had stated that the extent to which key personnel have to commit to an offer depends on what the solicitation requires. And in this case, the solicitation did not require offers to obtain commitment letters from proposed personnel, or it didn't specifically say that it, required offers to verify the continued availability of its proposed key personnel or update the agency regarding that. So all in all, this case, at the end of the day, the solicitation at issue in Golden IT didn't require letters of commitment. It just required key personnel descriptions and resumes. So, in conclusion, that it was the court's opinion that GAO's rule should be rejected that requires offers to update an agency regarding key personnel. Now, I think it's really important to note, and I don't think that this should be read that, going forward, GAO or the court isn't going to find that, failure to advise the agency of, an unavailability of key personnel after proposal submission isn't going to be found to be a material misrepresentation, and so on and so forth. I think we have to wait to see, what GAO cases, decisions come out post Golden IT, and same with the Court of Federal Claims. And, who knows, maybe this will go up to the Federal Circuit at some point. But it is a light for contractors that, it's, possible that this GAO rule will start to kind of lose its momentum. But that really remains to be seen at this point. Eric, I don't know if you have any more thoughts on that, but it certainly will be interesting to see.
No, definitely will be interesting to see. I think, the case kind of highlights something that we'll bring up later in this presentation, which is, I think there is a definite choice that contractors need to make when protesting of which forum they want to go to. If you have a key personnel issue, obviously, I think at this point there is less risk to go to the GAO, but we'll see if the GAO reconsiders its position in light of the judge's holding in Golden IT. And then also, for the government contractors online who are less familiar, Court of Federal Claims decisions by an individual judge are not binding on other Court of Federal Claims judges. So it will be interesting to see as well how the other judges of the Court of Federal Claims, decide similar cases going forward if they adopt the GAO's rule that, GAO has long held, or if they adopt this new reasoning by Judge Solemson in Golden IT. And we'll just have to see how that plays out. But, I think substantively, if you think that there is a key personnel issue with the awardee and you are protesting the award, it appears to us that there is the better, more receptive forum at that point would be the GAO to bring that protest argument. So that takes us to the next case, which is Sierra Nevada Corporation. And I think that, in many protest scenarios, what we normally think of is a competitive award situation where, I, as the government contractor, submitted my proposal, another government contractor submitted their proposal. We got into a competition with evaluation factors and, they won or we won, and now there's a protest. I think what Sierra Nevada shows is that there are other opportunities that government contractors need to be aware of and other, information that government contractors need to be tracking, specifically sole source awards, which provide generally right grounds for protest. So just as a little background, the Competition and Contracting Act, which is the statute that guides some of the principles in the FAR, requires agencies to use competitive procedures to obtain full and open competition, generally. However, the FAR provides several exceptions to the requirement to obtain full and open competition, including when the services or goods are available from only one responsible source and no other type of good or service will satisfy the agency's needs. Prior to an agency awarding a sole source contract, a contracting officer has to jump through a number of hoops. Essentially, they need to prepare what is called a justification and approval for the sole source award, and they need to justify their decision, including, why the proposed contractor's unique qualifications requires the use of the sole source authority, what efforts the contracting officer went through to ensure that they received as many proposals as possible, and a number of other things, whether the price is going to be fair and reasonable, and what other facts support this use of other than full and open competition. And any of those decisions in that justification can be challenged by a government contractor as being arbitrary or unreasonable, which leads us to Sierra Nevada. In 2014, the Air Force awarded a contract to Sikorsky to develop a combat rescue helicopter to replace the somewhat aging fleet of helicopters. And then 5 years later, the Air Force determined that the helicopter's capabilities required some updating. So to figure out what the best way to update these capabilities was, the Air Force issued a sources SALT synopsis. And that is issued generally on sam.gov. And you can go look at those and figure out if your agency is looking for sources SALT. The agency also held an industry day and did a number of other outreach events to industry to figure out what contractors could provide these capabilities and update the capabilities of this helicopter. Sierra Nevada submitted a response, but their response only focused on one particular type of upgrade instead of the full complement of upgrades. And the agency came back to Sierra Nevada because they'd worked with them before and said, you may want to go back and reconsider your response and submit an updated response. So 9 months later, Sierra Nevada comes back and they submit this updated response. But in the interim, the agency had already gone through the justification and approval process and, developed all of their documentation, and decided that they were going to award a single source or a sole source single award IDIQ contract to Sikorsky with a 5-year ordering period. And the agency claimed that Sikorsky was the only contractor that had the technical data package that was necessary to perform these upgrades. They had the technical information regarding the helicopter because they had built the helicopter under the prior contract. And while that technical data package should have been released to the government or should have been the government's property, there was some dispute between Sikorsky and the government over who owned the technical data package at the time of this award, meaning that other contractors didn't have the capabilities to perform this work, according to the agency. So Sierra Nevada was tracking this situation, this sole source award, and they protested the sole source award in the Court of Federal Claims. And the Court of Federal Claims sustained the protest. The Court of Federal Claims importantly held that the Air Force was not required to consider Sierra Nevada's second submission, its updated submission to the agency before awarding the sole source contract. And that was important because for government contractors, Sierra Nevada's first submission lacked a number of details that the agency thought was necessary in order to make this determination of whether another source could actually perform the work. In Sierra Nevada's second submission, its revised submission, they actually maybe provided enough detail to make the award unjustifiable on that grounds, that there was more than one responsible source and the agency should have conducted some sort of competition between Sierra Nevada and Sikorsky. But because Sierra Nevada waited so long to submit their second submission, and because they did not include the information in their original submission that they maybe should have included, the court held that there was no requirement to consider this second submission after the agency had already gone through this justification and approval process. The court agreed with Sierra Nevada, however, that the justification and approval did not justify this long-term 5-year sole source IDIQ award to Sikorsky. And the reason for that was that the agency represented that it was going to receive the technical data package sooner than 5 years from the date of award. So a sole source award to Sikorsky for that entire time frame of 5 years was unjustifiable in the court's opinion. The court also held that the Air Force failed to meaningfully consider other types of contract vehicles other than the sole source IDIQ to mitigate that the unavailability of the technical data package. So in particular, the court suggested that a multiple award contract vehicle would allow for full and open competition as soon as that technical data package became available to the agency and then available to other offerers. So I think the teaching of this case is just that contractors should be not only monitoring competitive competitions, but also potential sole source awards in your space. And there may be reason to challenge those as well. And if you do challenge those, often those decisions are ripe for challenge because often there is some government overreach in the length of the award or the market research that had been done prior to awarding the contract. And with that, we can go to the next slide. And we can go to the next one also, Frederick. Thanks. I'm going to turn it over to Katie.
Okay, so the next case we're going to talk about is Sagam, and it deals with, it was actually a pre-award protest, but it addresses the timeliness of an intervention. So it's kind of interesting. In this case, the protests were originally filed at GAO. GAO dismissed the protests. So Sagam subsequently filed at the Court of Federal Claims, and it had, expressly stated that it didn't wish to intervene in that Court of Federal Claims protest. A few months later, the Court of Federal Claims sustains the protest, and the government files its notice of appeal to appeal to the Federal Circuit. And then after the government filed its notice of appeal, the awardee requested to intervene in the case. And the Court of Federal Claims held that, the intervention was untimely, or the request to intervene was untimely. And in holding, the court relied on 3 different factors, which were identified in a much earlier case, but it reiterated that it considers 3 factors when determining whether a motion to intervene is timely. The first factor is the length of time during which the would-be intervener actually knew or reasonably should have known of his right to intervene in the case before he applied to intervene. And that's relevant here because the awardee knew as early as the GAO dismissal of what the bases of protests were. And certainly at the time that the agency, that the Court of Federal Claims issued its decision, which was almost 2 months prior to the protester filing a notice of appeal. But, you know, the awardee sat on its rights and didn't request to intervene until after that notice of appeal was filed. The second factor is whether the prejudice to the rights of existing parties by allowing intervention outweighs the prejudice to the would-be intervener by denying intervention. And the last factor is the existence of unusual circumstances militating either for or against the determination that the application is timely. Here, the court found that there were no unusual circumstances. And with regard to prejudice, the court found that really there was no prejudice because the awardee could still intervene in the appeal before the Federal Circuit, which it had filed a notice of intervention. So, you know, this is a interesting case from a timeliness perspective, from an intervener's perspective. You know, there is no hard and fast rule other than these factors, but there's no specific, you know, date certain that you have to intervene by. But these are factors to consider, you know, as an awardee as to whether or not you're going to, you know, defend your rights and help the agency in defending the award decision. So yeah, ultimately the Court of Federal Claims denied the intervention in that case. So just something to keep in the back of one's mind when deciding whether or not to intervene or not, and at what point when you're talking about a Court of Federal Claims case. With regard to GAO, you know, there's also no hard and fast rules for intervention, but a kind of a rule of thumb is to intervene before the agency issues its agency report. And the agency report gets issued, you know, typically 30 days after filing of the protest. So something to keep in mind there as well. Eric, do you want to talk about COFC concealing order? That slide? Thanks.
Yeah, so with about 5 minutes left, we'll kind of run through these 2 cases quickly. In the first case, Owens and Minor Distribution, we're dealing with an extremely complicated protest litigation involving multiple protests. There were at least 2 protests involving different issues with different parties on different sides of the equation, plaintiff and defendant. But fortunately, we don't need to get into those issues. The part of this case that we're going to talk about is voluntary remand. And voluntary remand at the Court of Federal Claims is the equivalent at the Court of Federal Claims of the agency taking corrective action or requesting corrective action at GAO. Something that we'll go back, we'll take a look at this, and then we'll come back later with a new award decision or a new solicitation provision, what have you. Anecdotally, we've seen DOJ requesting voluntary remands in protest litigation more frequently in recent years than we have in the past at the Court of Federal Claims. And while GAO often will just grant an agency's request to take corrective action, stating that it moots the protest grounds, the Court of Federal Claims has recently shifted and started scrutinizing these motions for voluntary remand more carefully. Until about 3 years ago, the court and courts around the country had routinely granted motions for voluntary remand almost as frequently as GAO had. There were maybe a handful of cases in where a motion for voluntary remand had been denied. However, starting a few years ago, Judge Solemson was new to the bench, issued a decision called Keltner, and in Keltner, Judge Solemson denied a motion for voluntary remand and laid out a test that said, the court will grant a motion for voluntary remand where the agency provides a compelling justification for its remand, where the need for finality in the litigation does not outweigh the justification for voluntary remand, and where the scope of the agency's remand request is appropriate. In this case, the Court of Federal Claims followed Judge Solemson's lead, a new judge as well, Judge Tapp, adopted the Keltner test and found that the agency's request for voluntary remand did not satisfy the factors. In particular, the court held that it did not question the candor of the United States, that its request was substantial and legitimate, but it was not going to just assume that every motion for voluntary remand was based on a substantial and legitimate reason. And the agency that was actually taking the action that would go back and do the voluntary remand had not put in any sort of evidence to that issue. Judge also held that even if the motion had been properly supported with that compelling justification, the remand would be inappropriate at that stage because there was a need for finality in this case. During the course of the litigation, the government had repeatedly confessed error in open court, noting that its administrative record didn't adequately support its decision. And the court said, we see no need to stay our hand when the United States has admitted that its decision on the merits will spur this prompt corrective action. Basically, it was not going to let the government go back and paper over the record just to come back into court when the court could do the same thing and sustain the protest and enjoin the procurement at that point. The next case that is important in instilling order is Oak Grove. And Oak Grove highlights the difference between the record in a protest at GAO and the Court of Federal Claims. At GAO, the agency is required to produce the relevant, in quotes, documents. And so what that means is that in the first instance, the agency gets to curate its record and determine which documents are relevant. And because protesters often don't know what they don't know about what other documents may exist, the protester has less likelihood to get access to those documents that might be relevant, but which the agency has withheld from production. At the Court of Federal Claims, the administrative record is supposed to include the entire administrative record. That is every document that has touched the agency's procurement and decision-making. And often generally, there are no battles over the record documents at the Court of Federal Claims because everything gets produced. In Oak Grove, the government, the protester went to the GAO, requested documents, and essentially was not getting the documents that it thought it was supposed to get. Its protest, the GAO ended up denying the protest, and the protester took their same protest to the Court of Federal Claims. At the Court of Federal Claims, the agency produced a record, and both the protester and the judge, throughout various points of the litigation, found that documents were missing by looking at the documents that the agency had produced that referenced other documents that were not in the record. And the judge repeatedly ordered the government to produce these records. And at the end of the litigation, the judge actually sanctioned the government attorney for record production issues for not producing the entire administrative record at the outset of the protest. And I think that just goes to highlight the fact that as it pertains to certain issues, there was a organizational conflict of interest challenge in Oak Grove, where certain documents you may not know what exists with regards to which parties have access to which information or which parties were discussing issues with whom, that the Court of Federal Claims may be a better option in that case because you likely will get access to the entire administrative record, including those relevant documents. With just a few minutes left, Frederick, we can go into the tips real quick. And we covered a lot of these during the course of talking about these cases. Vigorously defend your awards as the intervener like we discussed early on with the GAO protest statistics, the corrective action stages where the bulk of the effectiveness rate for GAO comes from. So get counsel involved early, reach out to an agency early, and build that relationship of trust with your agent. Frederick, next slide. And also protest strategically. Harmonia teaches everyone to challenge solicitation ambiguities when appropriate. You want to gain as much information as possible through your debriefings, but be aware of the timing of your protest. And you want to pick your field of battle appropriately. Like we just said, if you have an OCI challenge, perhaps the Court of Federal Claims might make more sense because you're going to have access to more record documents. If you have a key personnel issue, like Golden IT teaches, perhaps the GAO is the more favorable protest forum. And then pick your battles. As you're going through your own thought process as a contractor, not every protest argument or every gripe you have with the agency is going to be a winner. As GAO's protest statistics show, there are frequently sustained protest grounds. And so start to be thinking of those protest grounds as you're doing your own research. And then as the attorneys involved, Katie and I can certainly identify the protest grounds that would be viable as well. I think with that.
One last thing, just to answer, that looks like there was a quick question here, whether or not contract awardees have the right to see the basis of protests. So if you intervene in the protest, you would have a right to see the redacted protest, either at GAO or at the Court of Federal Claims. If you don't intervene as awardee, usually you can reach out to the contracting officer and ask them to provide a copy of the redacted protest. Typically they provide it to you, but not always. So there isn't a right, so to speak, to get the redacted protest, but certainly request it if you aren't intervening in the protest. And even if you are intervening, sometimes you want to try to see a copy of the redacted protest first to find out if it's meaningful for you to intervene. Typically, if it's a post-award protest and you're the awardee, you're going to want to intervene. But sometimes in multiple award contracts, it might be, there might be reasons that you wouldn't intervene. But we have run over. So we appreciate everybody's time. And, if you have any questions or want to reach out to us regarding today's webinar, please feel free to do so. And we, again, thank you for your time. Have a great Wednesday.